ask that Mr. Stetz be placed on the docket today after visiting with him at the jail um, for the sole purpose of the court revisiting his bond. It's my understanding, Your Honor, that his bond is currently set at $100,000. That may actually be a reduction from what his original bond was set.
It appears that's true.
Your Honor, I did not argue if I did, I don't recall it, the initial bond reduction. Mr. Stetz is 19 years old. I don't believe he has any criminal history whatsoever. He was gainfully employed, at least at the time of the arrest, at Ranger Boats. I have talked to his mother, Heather, and he has a place that he can go and live, and he has told me that he is willing to essentially be under house arrest, ankle monitor, whatever the court would order if his bond can be reduced to an amount of $20,000. Your Honor, I know that this is an alleged very serious offense. We don't take that lightly. We don't think that, or I don't think, from what I've been able to gather from talking to Mr. Stetz and looking at my file, that he is the major player in this incident. And given the conditions that I've set out for his release, given his age, given his lack of criminal history, we would ask for the bond reduction down to $20,000.
What says the state?
Your Honor, it's the position of the state that the initial bond was reduced. Upon that happening, Your Honor, the court looked at the facts, presented to the court, made a decision $100,000 was appropriate. We think it is still appropriate, Your Honor. It's a Class Y felony this individual is charged with. I know he is young, but the crime is very significant. Fortunately, it was interrupted before it got any worse. We would just ask the court to leave the bond in its present situation, Your Honor.
What the record reflects is that he appeared in front of Judge Putman on May 28th on this charge, and he was arraigned and entered a plea of not guilty, sat down to reappear on June 4th, and Judge Putman on that date reduced the bond to $100,000. On June 4th, he appeared in front of this court, and the court set it off for a next appearance on the 24th of September, which I believe is that's the date on the scheduling order. On that date, the issue of bond doesn't reflect that it was discussed on that date. Or if it was, then I obviously felt that the bond was appropriate.
I think it's also relevant in this case that the statements that initially were given by Mr. Stetz to law enforcement were not true. It was not until later that he gave a true statement, which concerns us also, Your Honor.
Your Honor, I'm aware of the concerns of the state, and but I would reiterate that this gentleman is entitled to a reasonable bond, and certainly a reduction of some amount of this bond, given the factors that I've outlined to the court, I think would be appropriate. He fully understands that there would be a no contact order, a complete no contact order with the alleged victim.
Court's going to make the ruling at this time that the bond, as it said, is proper and appropriate. I'm not going to reduce the bond. If there's further factors for the court to consider, the court's always open to receiving additional information, but at this time I'm leaving it at $100,000. And it will, if there's going to be any bond that I set is going to require that there be absolutely no contact with the victim. So that's where we are right now.
Thank you, Your Honor.
I'm going to go and look at 2015 192, 2015, 196, State of Arkansas versus Logan Walters. These are both these cases are for arraignment. I've already made the appointment of the Public Defender's Office to represent Mr. Walters. On the charges in 2015, 192, which are breaking or entering, Class D felony, 38 counts. Theft of firearm, Class D felony, 2 counts. Theft of property, Class A misdemeanor, 25 counts. Criminal mischief in the second degree, a Class B misdemeanor, 3 counts. On those charges, how does Mr. Walters plead?
Your Honor, he pleads not guilty and waives formal reading of the charges.
In 2015, 196, Mr. Walters is charged with breaking or entering, Class D felony, 2 counts. Theft of property, Class D felony. Theft of property, Class A misdemeanor. On those charges, how does he plead?
Not guilty, waive formal reading of the charges.
Both these cases being on the Division 4 docket, the court will set them by scheduling order for trial December 7th, pretrial November 19th, and a reappearance on October 22nd. Is there anything else to be taken up at this time?
Your Honor, given the multitude of charges and our recent appointment, I will go over to the jail and visit with Mr. Walters, and if we cannot get some sort of bond that worked out with Mr. Etheridge, then in all likelihood I'll ask that he be, I'm not going to ask it today, Your Honor, but I may ask that he be placed on the July 30 docket. But no further issues today, Your Honor.
That'll be fine. July 30th? Is that what you?
Yes, Judge.
Okay. I note, I'm just trying to see. I noted that the bond has been set at $50,000. That's where it is right now.
Your Honor, I just need to be able to visit with him to articulate where he would live and the reasons that I can give to the court in a fashion that would be presentable, and that will not be done today given our recent appointment.
Very good.